Hello, good morning. Happy Saturday. My name is Meghan Maes, and this is Being in Civil in Minnesota. I am an attorney and a mediator. I live in North Mankato, Minnesota, and I like to do this podcast because I think there's a lot of great information on the internet, but I think there's a lot of terrible information on the internet. I want to make sure that people are getting access to the right information. So I have a Facebook group, and if you have questions about family law or the court process, you can go ahead and post those in Being Civil in Minnesota. This does not make me your lawyer. I'm not giving you legal advice. One of the questions we got in our group recently was about motions for temporary relief and what happens at those hearings. So that's what we're going to cover today. This is an important topic because these cases can take months, years when you're dealing with custody or parenting time. There are lots of good reasons why there may need to be some sort of order or agreement on how things are going to move forward while you guys are separating, uncoupling, or going through a divorce. So obviously life doesn't stop when you're going through a separation. You're going to have school, you're going to have activities, you're going to have expenses. And so finding a way to navigate that in the least adversarial manner is going to help save time and money. But if you can't come to an agreement, you can file a motion with the court. So what is a motion for temporary relief? It is a request that is made by someone for the court to issue parameters or rules regarding certain topics while the matter is going through the process prior to the court issuing a final decision. Orders can help stabilize things during this long process. A lot of issues that are common to see in motions for temporary relief are what is the schedule for the children? Is there going to be bills or mortgages, car payments, things like that that need to be addressed? Who's going to pay what during the interim, and how does that impact things? So you'll see custody. Parenting custody is who makes decisions. Parenting time is the schedule for the kiddo. Child support, spousal maintenance, and sometimes even attorney's fees. So there are ways to get need-based attorney's fees if you are unable to financially afford someone to represent your legal interests and the other person has those resources. Sometimes there is an ability to request attorney fees, need-based attorney fees in a motion for temporary relief. So how does it work? Well, it starts by putting down what you want in something called an affidavit, which is a sworn statement under oath, under the penalties of perjury. It is a crime to lie in an affidavit. I've seen very few cases of perjury being charged out, but I've seen many instances where I believe perjury has happened. So you always want to be ready and you want to bring your receipts. So when you have your statement, back it up with as much neutral, relevant information so that the court can, if they have to make a credibility determination, this parent says the sky is purple, this one says it's blue. If you have pictures of the sky being blue, the other person can shout purple all they want. The court is able to see what's really going on. And that's going to be the case when you're dealing with a adverse party with narcissistic tendencies. Okay, so it's a sworn written statement, what you're asking for and why, and that goes with a motion. You can't just typically, unless there's very limited circumstances, just get into court tomorrow. You have to have your documents served on the other party several weeks in advance of the motion hearing. And then they get an opportunity to submit a written response responding to your request for relief. At the hearing, you will appear. The other party will appear. Lots of times these are happening via Zoom. The court will call the case. We're here in matter whatever. They'll note the appearances of the parties, and then each party will typically get an opportunity either themselves or through their attorney to give a very brief overview of what they're asking for and why. The court is going to review the paperwork, so you don't have to read everything to the court. You want to give the court a summary. Once that's done, the court issues a written decision, and a court has up to 90 days to make those written decisions. So if you know that you need relief, schedule those and think about how much time it might take. If you ask a court, say, our house may go into foreclosure, we would really appreciate an order at the court's earliest convenience. If you let them know it's time sensitive, they can at least take that into consideration. The legal standards, right? So when I said give the court relevant information, they do not want to see 288 pages of text messages. There has to be a way for you to document and turn those messages into data that the court can use. For example, in those 200 plus pages of text messages, you offered the other parent to see the kiddo 7 times. And on the 8th time, you said, I'm not going to continue to reach out. If you want to see your kid, let me know. That information would be very helpful for the court if the other parent might try to say that you are withholding a child or keeping a child from them. That's the kind of documentation and that's the kind of receipts that the court is interested in knowing about, because when they say that the sky is purple, you've got the information, but you have to put it in a form and explain it in a manner that helps the court give you the relief that you're asking for. A couple tips, not legal advice. Be truthful and show your work. If you have multiple messages offering the children, show those messages. Count how many there are. Put it in a timeline so that the court knows that through April of 2023, you tried to let the other parent see the kiddo, but then you stopped reaching out because it's not your job to make them be a better parent. Keep your documentation organized. Make sure it's chronological and in a way that is easy for the court so that they can locate parties' incomes if there's child support, for example. Stick to the facts. These are high emotion cases, and it can be incredibly frustrating if there is something that is really impacting your case, but maybe isn't relevant to co-parenting. So those are kinds of things that are not going to help your case. And so sticking to the facts, which are what is in the best interest of your children. And if you can relate those bad facts to concerns you have or relevance regarding the children, then you can bring in that information. So there are forms on the Minnesota Judicial Branch website that talk about how to file a motion for temporary relief, and it has court forms with instructions on what to do with those forms and how to fill them out. lawhelpmn.org is also a great resource. It explains kind of the rules in the state of Minnesota. If you have questions or somebody you know has questions about family law or the court process, please join the Facebook group Being Civil in Minnesota on Facebook and come here to see the episodes. This is episode 49. Excited to do episode 50 and appreciate everybody supporting this platform. If you have questions, let me know. Have a great Saturday.